Yeah, we're trying to get Eddie's to take that first.
No, we're gonna have to plea in that case, if you'll give us a few minutes to do the paperwork.
Humboldt versus Jeremy Vermal. Jeremy Vermal.
Yes, sir. Yes, sir.
Last four digits of your social security, 0440.
Yes, sir.
You're at 23 CR 0046.
Yes, Your Honor.
What's the Commonwealth have to say?
Judge, we have a resolution. Yes.
What does the Commonwealth have to say?
We have a proposed pretrial diversion plea, Your Honor.
What's the charge?
One, main criminal mischief.
Tell me a little bit about it.
Evidently, he and two other young people got in an altercation at the Green Trailer Park. Mr. Burnell reportedly ran his car into the back of another car, doing $2,650 worth of damage. He didn't have any.
Motion was tendered that says you wish to enter guilty plea. Is that correct?
Yes, sir.
Are you currently in the courts of drugs or alcohol?
No, sir.
Plead freely, voluntarily.
Freely.
For the same person named in indictment number 23 CR 0046.
Yes, sir.
Is your judgment impaired today? Is your judgment impaired? You know what's going on?
No.
Have you discussed these charges with your attorney and you satisfied with his advice?
Yes, sir.
Can you read the evidence Commonwealth has against you to believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept your plea, I need to know that you understand those rights. I'm going to go over the rights and ask you to acknowledge that you understand them. You have a right not to testify against yourself in the one to say anything, right to speak your out, but jury, right to be represented by counsel, to jury trial, right to confront and cross-examine witnesses, come and testify against you, your right to produce evidence, right to call with witnesses in that process issue, compel their attendance. You have a right to appeal this matter to higher court if you lose, your right to file a Commonwealth for these charges. Today, that you give up all those rights. You understand that?
Yes.
And I may consider the Commonwealth's recommendation to their applying range of sentences out of the law. If they do not accept the recommendation and decide it could be a harsh punishment or sentence, you can withdraw your plea and proceed to trial. I'm going to ask you some qualifying questions. Have you had a diversion within the last 5 years?
No.
Have you been since the last 10 years?
No.
Are you on probation?
No.
Okay. You understand if you fully complete the diversion agreement, the charges will be dismissed pre-trial very however, if you fail to complete the diversion agreement, you can draw back from the court for a sentence investigation will be ordered. Be sentenced to be a convicted felon. And if you have any felonies in the future, those sentences could be enhanced. You understand that?
Yes, sir.
You all step to your left here. Mr. Stockton, sir, listen real closely.
Your Honor, he'll plead guilty, wanton endangerment first, 2 counts, and criminal mischief first degree. Receive 5 years on each charge, run concurrently for a total of 5 years. Be pretrial diverted for 5 years. It's to be supervised. He'll receive credit for time served. He'll also plead guilty to failure to maintain insurance on a motor vehicle, receive a fine of $500 plus cost. Also pay restitution to the victim in this case of $2,650 at $250 a month, beginning within 30 days from the end of this plea and the first day of each month thereafter. You'll maintain gainful employment and have no contact with the victim.
Step back there. Is that what you agreed to do?
Yes, sir.
I'll accept the pre-trial diversion. What's the total?
$655.
That sound about right?
Alfred All Finance Court Hospital.
Get your signature on the document. You need to meet with the probation parole officer here, here the conditions. Okay.
Yes, Your Honor.
And we have a few Cumberland County people working around here, I think, so. These are Cumberland County. Bobby.
Your Honor, you want to start with the transport?
Yes, Bobby Thurman, Bobby Phillips, excuse me.
Bobby Phillips.
Grand jury drawing 165. $424. $84. $98. Commonwealth of Kentucky versus Bobby Phillips. Bobby Phillips.
Yes, Your Honor.
We're on 21 CR 00110. Were you born in 1968?
Yes, Your Honor.
Last four digits, social security number 5121.
Yes, Your Honor.
You're here for pretrial conference. You represent the Office of Public Advocacy. Move to your left just a little bit, please, sir. What does the Commonwealth have to say?
The Commonwealth needs a little additional time, Your Honor. We had trouble locating the victim, Mr. Winningham. He had a stroke and he was in the Overton County, nurse is in the Overton County rehab. I went by there the other day and visited with him. But I promised his daughter I wouldn't discuss the case with him until she was present. So if we could place,
What's the date next month's pretrial?
I would ask for January, yes, if we could. He's a state prisoner and I want to get something done about it. Give me time to meet with her and talk to Mr. Pennington both.
I know, I was just thinking, what did you do? December 7th, 16th,
I think it is.
January 11th,
Yes.
and you want a negotiation then?
Yeah, we'll set the one in January. We'll set it on that day. We'll do north. It's all right.
Both of those, the negotiation day in January and your court appearance is January 11th.
Be here in person. We need to be here in person next court day.
Well, but his attorney will do the transport order. Thank y'all very much. First, the transport order.
Yes, Your Honor.
Jesse Pittman. Jesse Pittman. Commonwealth versus Jesse Pittman, 23 CR 0037. Jesse Pittman,
Yes, sir.
born in 1968.
No.
86, excuse me. Yeah, I thought you'd aged very well. 68. You just gained 20 years of life.
Yeah.
This is 23 CR 0037. Here for a pretrial conference. What's the Commonwealth have to say?
Your Honor, this case, the victim in this case is in rehab at this time. After quite a bit of difficulty, I was finally able to contact her and talk to her about this case. There's some evidentiary problems with this case. And based on that, plus what the victim has told me, and the fact that Mr. Pittman has been flopped for 1 year by the parole board, I'm moving to dismiss this case without prejudice. It's a kidnapping or unlawful hold and an assault force, basically. And I could go into detail, but I wouldn't want to do it on the record about the case. But that's.
You dismissed it without prejudice.
That's correct.
Any objection?
No.
Judge, given, and I know this raises additional issues that,
Get behind the microphone.
yes, Your Honor, I know this raises additional issues that may need to be addressed by motion, but given the deferment was the basis of these charges, we would just ask for any leave that the court would have or the ability to get Mr. Pittman back with his life.
Firm.
Yeah, that's gonna be up to the parole board, so I don't know.
Well, you talking about us finding that he violated,
Correct, Judge.
so we revoked his
Correct.
probation.
No, I
Or
thought,
parole.
no, so we didn't have anything to do with it. Parole
Parole
board
board.
revoked his
Based
parole
on the charge.
based upon these charges without conviction, so we didn't have.
What we had.
That's-
I don't really.
Okay, well,
I didn't know how we played the part.
We didn't.
Sorry.
Judge, I'll,
You can draw an order if you want to, that's a separate order that's a little bit more expansive than the normal order of dismissal without prejudice. And see if Mr. Stockton signed it, that might be of some assistance. Okay?
yes, Your Honor, thank you.
Thank you very much. Alfred Silva. Silva. Commonwealth versus Alfred Silva, 23 cigar 0021. Are you Alfred Silva?
Yes, sir.
Born in 1962.
Yes, sir.
Last four digits, social security number 23. Excuse me, last four 3706.
Yes, sir.
This is your 23 cigar 0012 for pretrial conference, but it's Commonwealth.
We have a parole.
Felony plea or a.
Yes, it's a felony plea.
So, as you heard, I've just been informed that you could file a motion to enter guilty plea today. Is that correct?
Yes, sir.
Currently, influence drugs or alcohol.
No, sir.
This is plea free and voluntarily given.
Yes, sir.
Are you the same person named in the indictment? Number 23 CR 00012.
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, Your Honor.
The evidence Commonwealth has against you, you are fully informed about your case.
Yes, sir.
You understand that you do not have to enter guilty plea. You have certain rights under the Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself, nor to make a statement. Right to speak, right to jury, right to be represented in counsel, right to complain, cross examine. Witnesses that the Commonwealth has against you, right to produce evidence, right to call witnesses in the federal and process issue. You have the right to bill this matter to higher court if you lose, right to call the Commonwealth within a reasonable right which you get charged, but you understand. Please give up all those rights.
Yes, sir. I understand that.
Now, when you consider the Commonwealth's recommendation, they have 90 days of sentence allowed by law. You not have to accept prior to accepting the recommendation of Commonwealth, I order the pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation to decide that those are harsher sentence, you have the right to withdraw your plea from the jury trial. Do you understand that?
Yes, sir.
Mr. Stockton, you come forward and announce what the Commonwealth's recommendation is.
Mr. Silva would plead guilty to the amended charge of unlawful transaction with a minor second degree, receive a sentence of 5 years. He'd also would plead guilty to sexual abuse second degree, receive a sentence of 12 months. Those would run concurrently for a total of 5 years. He served 290 days in jail. He would have the balance probated, supervised, be released at sentencing. He'd have no contact with the victim, and he'd receive credit for time served. And once he's released, he'd maintain gainful employment.
Okay, the victim's advocate is in contact with the victim.
Yeah, I've met with the victim and her grandmother. They're in agreement with this plea. And the problem with this case is evidentiary.
No, I don't.
Okay.
If
They're in agreement, yes.
Okay, I'll order a pre-sentence investigation report to be done by probation and parole. And you'll be back here on December the 7th. Okay.
Yes, Your Honor.
Judge, you want to verify?
Is that your signature?
Yes, sir.
Thank you, Your Honor.
Daniel Boston. Caldwell versus Daniel Boston, 23 CR 0004. Daniel Boston,
Yes, sir.
you born in 1982.
Yes, sir.
Last four digits of social security number 9048.
Yes, sir.
You're on a pretrial conference. Was it Caldwell?
We can have the December 7th date, we conclude this case after the key trial.
You need a, you don't need a negotiation.
No, Your Honor.
December 7th, condition your bond.
Just
Brett Carver. Commonwealth versus Brett Carver, 23 CR 0049. Brett Carver,
Yes, sir.
born in 1976.
Yes, sir.
Last four digits of social security number 589. What's the Commonwealth represent?
Your Honor, I need to meet with representatives of Bluegrass, and then if we can set a negotiation date for December the 1st, we can either resolve this or get a trial date.
I think there's many moving parts with all this. I don't know if we can get anything done by December 1st, but.
Well, let's set, you want to set a trial date then, if there's no reason to negotiate?
No, when I say moving parts, Your Honor, I'm saying that it's difficult to be able to negotiate with all the moving parts there are regarding Carver. I'm just saying well, primarily, and then there's that underlying case in district court, which we're having to hire an expert in that one. And it's just really
Well, I need to meet with Bluegrass and go over the case with them. Once I do that, I can
December
decide whether I'm
1st.
gonna ask for one.
Negotiation may be December 1st, and then be back in court on December 7th, and both of those are conditions.
We'll be at some. At 9 a.m. or 1 o'clock.
Virginia Catherine. Virginia Catherine. Commonwealth versus Virginia Catherine. 23 CR 0045. Are you Virginia Catherine?
Yes, sir.
Were you born in 1985?
Yes, sir.
Last four digits of social security number 5109. What does the Commonwealth have to say about this case?
Your Honor, I think the last four of the social was wrong. She said it was 5809.
Conversion or?
It's just a felony plea, Your Honor.
Then a motion has been filed on your behalf, says you wish to enter a settlement with the state. Is that correct? Is that correct?
Let me
Yes.
speak up.
Are you currently in the use of drugs or alcohol?
No, sir.
Is this plea free, voluntary, or given?
Yes.
Are you the same person
Yes.
named in indictment 23-0045?
Yes, Your Honor.
You discuss this matter with your attorney. Are
Yes.
you satisfied with his advice?
Yes, sir.
Are you impaired today in any way? And while you, the evidence Commonwealth has against you, you believe you're fully informed about your case.
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights of Kentucky and the United States Constitution require that you understand those rights.
Yes, sir.
We're over the rights, we at the end, I'm gonna ask you to understand, okay? You have the right not to testify against yourself, no one can make you say anything about your trial, but you're right. Represent the counsel to your trial, the right to confront, prosecute, I'll testify against you, right to say this, right to witnesses, okay? have to appeal this matter to higher court if you lose, or I require the Commonwealth to prove unreasonable doubt that you get insurance. You understand that the hearing and guilty plea, you let that shut. Understand that?
Yes, sir.
Now, may consider the Commonwealth's recommendation that I have since provided law, I do not have to accept your recommendation. Prior to accepting the recommendation, I will wait for the sentence investigation report and my formation of parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to jury trial. And Ms. Coordination, when you move over here, and you move to the left, listen very carefully, see if this is what you agree to.
Upon a plea of guilty to theft by unlawful taking or disposition of firearm, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall pay restitution in the amount of $900 plus a 5% clerk's fee at a monthly rate of $100 plus the 5% fee at a monthly rate of $105 payable at and to the Clinton Circuit Court Clerk with first payment due within 30 days from the entry of this plea. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is attained, and defendant agrees to have any and all evidence destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency in both style cases.
Go back to the beginning again, tell me what the charge was.
The charge is a theft by unlawful taking or disposition of a firearm.
Explain that to me.
Let's see.
Always.
My understanding was she was a live-in guest of Richard Cash. She stole some of his firearms, got one of them back, and now she's still doing some more work for Mr. Cash. So that's the situation there.
She wasn't previously convicted of.
No.
So, okay. Is that what you agreed to?
Yes, sir.
Pleading guilty because you didn't commit the charges and you died in this amendment. I will accept the plea. I understand that after ending this plea, if you have felonies in the future, it could be enhanced under persistent felony offender law. You understand that?
Yes, sir.
You plead guilty here, because you are guilty.
Yes, sir.
Now, is it still your desire to waive your constitutional rights and for dissent?
Yes, sir.
That's your signature on it?
Yes, sir.
Well, I'll accept the agreement. Was this a probated sentence?
Yes.
Well, I'll let you remain free on bond. And then send you will come back here on December the 7th. For sentence, okay, you do your probation for a while.
Change manager, yes, sir.
I'm sure it's right. I'm a swear or firm. Keep confidential on that. You protect your head, Constitution of the United States of America. So. Thank you, Judge. Virginia County.
Yeah, we just
I'm
finished.
sorry. Phil Martin, Jamie Harold. Commonwealth versus Jamie Harold, CR, Jamie Harold.
Yes, sir.
77.
Yes, sir.
That's 4 digits of social security number 3525. We're on 23 CR 0041. What's the comment?
We have a felony plea, Your Honor.
Cheryl, you want to have that there just for a second? I've been informed that the motion has been tendered, the city wish to enter a felony plea. Is that correct?
Yes, sir.
Are you currently at the first year of the alcohol?
Yes, sir.
It's been true involuntary given. Are you the same person that is named that number 23 CR 0041?
Yes, sir.
Is your judgment impaired today?
No, sir.
Okay. Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against
Yes, sir.
you? You believe that you're fully informed about the case? You understand that you do not have to enter guilty plea, that you have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand what you're saying. So we'll go through the rights, and then I'm gonna ask you to understand, okay? Your right not to testify against yourself, no one can make the same thing, your right to speak, trial by jury, your right to be represented by counsel at your jury trial, right to confront across the my witness, call testify against you, your right to present evidence, your right to call witness, process issue, other attendance. Your right to us whenever our court rules, and right to try to comment for the lawyers without which you have guilty charge, that you understand that when you guilty plea, you waive those rights, you understand that? And may consider the Commonwealth's recommendation, but I'm not being applied to range of sentence provided law, I do not have to accept the recommendation. Prior to accepting the recommendation, I will have pre-sentence investigation, probation, parole. In the event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that? So, you step to that, please. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. The defendant agrees to have any and all evidence destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Where are you working at?
Helping Journey off and on. Journey Froman, I've been helping him.
Is that your understanding of the Commonwealth's recommendation that she just went over?
Yes, sir.
You're pleading guilty because you didn't commit the act charging the violence as amended.
Yes, sir.
You didn't serve your own free will.
Yes, sir.
One of your constitutional rights is it still your desire to allow the court to sentence you to a term as permitted by law.
Yes, sir.
Okay, you understand that every plea future conviction will be enhanced towards your range of penalty. Under persistent felony offender law. So, that's your signature on the document. Now, this is a direct probation situation, so I'm gonna allow you to remain free on bond through the probation program. Thank you. Tower Hollow. Says that it was December 7th, in the last case.
Yes, Your Honor.
Oh, I see that.
Jamie, December 7th is next court date.
Are you Tyler Holland?
Yes, sir.
Born in 1996. Last year was a social security 698.
Yes, sir.
You're here on PCR 0040 for pre-trial conference. What's the time on this?
I believe we probably.
What is the charge?
Right.
That's correct, Judge.
We have negotiations.
We have.
What's
It's,
hand by hours of quantity?
no, it's quantity with other cooperation with regards to our making our
Was there anything wrong? November 29th, Thanksgiving Day or something. What is that? What about November 29th?
Judge, I think we already scheduled, I think we just scheduled negotiations for that day. At 9.
Now we're gonna be some first.
You have any
Oh, it's December.
November 29th.
One time, they used to have a worship service up here at 5 o'clock, Square. Christmas tree, other than that.
Well, we can break for that, we're still here.
Yeah, I'm just saying, I don't think, try park is a problem.
District Court.
That's what I was about to say.
That's
here,
what you-
I'm here in district court that day.
What about the 30th?
It's fine with me. That person's not available that day.
Is this that same white person that, with the, kind of some limited availability?
When is the last person available?
Go ahead.
She's available the 27th, 28th.
27th of November? That's the 27th.
Completed on the 27th, Judge. And my partner is for the
21st.
What about next day?
Her next available days are December the 11th and 12th.
How about no? December the 12th.
That's fine with me.
How about December 13th? December the 11th?
Yeah, let it stay.
Good.
Judge, I can make the 11th work.
Cody Key.
Are we doing December 11th?
I'm on versus Cody Key, are you Cody Key?
Yes, Your Honor.
Born in 1984.
Yes.
Last 4 digits, social security.
Yes.
Here on 23 CR. Won't be able to comment on this,
We still maintain a trial, Your Honor. I'm not saying clarification, give the victim, I think you just not that right there.
You haven't spoken to him about a possible disposition. Understand.
I'm sick for trial.
It's always there for December.
Yeah, 4th and 5th, you said you did.
Just got it down. Before, you think it'll take more than 1 day, Mr. Scott?
I wouldn't think so.
Your Honor, the court had 404B ruling, which in our opinion extended the time of trial for quite some time.
If I introduce that, it's not introduced.
Rodney Menace. All Manus. Rodney Manus.
Yes, sir.
1970.
Correct.
Last 4 digits of your social security number 3824.
That's correct.
Your day of probation notification. What is Commonwealth have to say?
We were here last month, I think Mr. Manis was supposed to pay $2,020 for the day.
21, so I paid a month ahead, I'm
That's
21.70,
That's right.
and there's my pay stub.
Okay.
Mr. Asher, tell me if there's anything wrong.
I'm going to make a place there for now. You want to schedule it for a date certain or continue it subject to renotice?
I continue to since he's caught up, but I'll keep watching this.
It wasn't you, was it, Mr. Hunt?
It wasn't me, Judge. It was something that was
I
supposed to be.
didn't want to accuse anybody else. You have broad shoulders, so I thought I would accuse you. Okay, you may be on your way, Mr. Manis. Commonwealth
Call
versus-
Mr. Lee's case, those officers. to leave.
Go back to a Cumberland County case. Commonwealth of Kentucky versus Bamboo. Over there. We did CR 0041. Good morning, Mr. Booth. Good morning, sir. This is 23 CR 0041, Mr. Booth, born in 1994.
Yes, sir.
Last 4 digits, social security number 4231.
Yes, sir.
I understand that you wish to enter a plea today, a motion to file, is that correct?
Yes, sir.
Okay. Are you currently under the influence of drugs or alcohol? This is a plea free, but voluntary to get. Are you the same person that indicted in Cumberland Circuit Court case number 23 CR 0041?
Yes, sir.
And is your judgment impaired today in any way? Discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Okay, have you reviewed the evidence Commonwealth has against you, and believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand this right.
Yes, sir.
I'm gonna go through those rights, and at the end of it, I'm gonna ask you to understand. If you don't understand, you step away and consult with your attorney.
Yes, sir.
You have the right not to testify against yourself. No one can make you say anything, right to speak trial or jury, right to be represented by counsel at your jury trial, right in front of cross examine no witness, call testify against you. Right to use evidence, right to call witnesses in your favor, right to this matter, higher court if you lose, and right to further comment, including the reasonable doubt that you guilty charges. You understand with the hearing, and you plead guilty, you give up all those rights. You understand that? I understand.
Yes, sir.
Yes, sir. Now, may consider the Commonwealth's recommendation, but I may claim major sense without the law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will order a pre-sentence investigation report to be done with probation bureau. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and have a jury trial. You understand that? Step to your left. Mr. Stockton, what's the Commonwealth's recommendation?
Your Honor, Mr. Lou, please, trafficking in a controlled substance is amended first degree, sentence of 5 years. He'll plead guilty to possession of a firearm by convicted felon, be a sentence of 5 years. They will run concurrently for a total of 5 years. The Commonwealth imposes probation and shock probation.
Is that your understanding of the recommendation?
Yes, sir.
Has anyone offered you or threatened you in any way to future plea?
No, sir.
Pleading guilty because you are guilty of the acts charged. Is that correct?
Yes, sir.
Knowing your constitutional rights to explain the sincerity of your desire, you have those rights to interplead the charges and allow the court to fix your punishment.
Yes, sir.
You understand that for any such plea will be used against you in the future and enhance the range of penalties. Is that right?
Yes, sir.
Get your signature on the document.
Yes, sir.
Now, the prosecuting officers are present here. Mr. Stockton, are they in agreement with this
Yes.
Plea agreement, yes, Sheriff. I'll accept either in the order of precincts investigation board, schedule a hearing in Burkeville. November 16th.
We have PSI done that fast?
They should, if they can, I'll let you know, I'll message you.
All right, thank you, Your Honor.
Trial will be canceled, and I guess we're to the court's office.
Yeah.
Commonwealth versus Darrell Murphy.
Paperwork, go back and forth.
The plea agreement, or do you all want to take it back?
Commonwealth versus Darrell Murphy, 19 CR 009, 18 CR 0015. Are you Darrell Murphy? Yes, sir. You born in 1974? Yes, sir. Last 4 digits of social security number 1535? Yes, sir. Okay, what was the Commonwealth have here?
Oh, misplaced my motion, looks like.
Mrs. Queen may have to. Mr. Murphy, at one point in time, I hope he doesn't anymore, had cancer and he was taking medication. And then later on, he had some positive drug screens and he couldn't provide proof of medication. He was also positive for oxycodone on September the 20th this year. And he denied use and it was confirmed positive for oxycodone.
It sounds like probation and parole is looking to refer Mr. Murphy to the Social Services Commission and follow those recommendations.
Well, that was what they put in the report. They were kind of frustrated because he was having these tests and wouldn't deny it. And so I'll do what, you know, what they want to do, Christie. This was Penny's case. Has he seen the SSC?
You know, stipulate to the drug use.
Judge will stipulate to the drug use, but I wouldn't like. Okay.
So I won't stop there. Yeah, Mr. Murphy. You heard the frustration that probation and parole has with you. Do you have any suggestions on how we might resolve this problem? And why are you not being truthful with them? If you've got a drug problem, there's no shame in that. You know, these people will work with you. Just need to be candid with you. When you cannot self-medicate, I understand you've had some health problems and stuff. What do you suggest? Are you working anywhere or are you disabled?
Disabled, but I help my brother sometimes.
On the farm?
Roofing.
Roofing?
Yeah.
I can't do much about any time being roofing up there. Keys.
I knew he was a drug court at one time when he discharged from your kids. You never completed.
I have not been.
Okay, I got you.
What do you think?
I think it might be a good idea. See, I doesn't have any suggestions otherwise.
That'd be, they use some structure, Judge Court. I'll sign a referral to the court, let them talk to you. See if you can work with it. That's just nothing that's that other.
You'd have to be drug tested, you'd have to go through the phases, and there's different requirements for them. I can't think of all of them right now. but you'd have to-
Well, usually you have to be employed, but if you're disabled, you don't have to do that. But you go to regular meetings and you have, and they'll get you help with various kinds of things if you slip and stuff.
Have a waiver of their initial kind of requirements. We can talk about that, go over it, and see where the referral goes.
My schedule will be back on the docket on December 7th. And I want to subject to, more frequent random drug tests between now and then. I'm not going to take you into custody today, but tell me, could you pass the drug test today? Probably not, right?
Prescription for hydrocodone.
Do what?
I take a bunch of medicine, I got prescriptions for hydrocodone.
Well, he's not going to be able to be in drug court because he's got a prescription hydrocodone.
Maybe we just need to have him assessed with SSC and review
Okay,
it
we'll
next
be
month.
back here on December 7th. We'll have you assessed by the SSC. And now, if you outreach and do this, we'll do a good order.
Yes, Your Honor.
You can get that done.
Robert Myers,
606.
Hello, Vic versus Robert Myers. Hello versus Robert Myers. 21 CR 0081, 23 CR 0036. Is this for you, Robert Myers Jr.?
Yes, sir.
Born in 1967.
Yes.
4 digit social security number 9705.
3705?
9705.
No, sir, 93705.
931.
37.
Yeah, 3705.
What are the last 4 digits? No 9 in it.
No, sir.
So 3705. You heard the 3-hour conference. Have you already seen our resolution?
We have, Your Honor.
Felony plea.
Yes, Judge.
A motion has been tendered, and I've just been informed you wish to enter a plea today, is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely voluntary?
Yes, sir.
Are you the same person that is indicted in 21 CR 0081 and 23 CR 00036?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you had the time to discuss this matter with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Review the evidence Commonwealth has against you.
You what, sir?
Have you reviewed the evidence Commonwealth has against you?
Yes, sir.
You believe you're fully informed about your case?
Yes, sir.
Do you understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go down through the rights at the end to ask you if you understand, okay? You have a right not to testify against yourself, no one can make you say that, right to speak trial, but jury, right to be represented by counsel at your jury trial. Right to cross-examine all witnesses called to testify against you, right to use evidence, right to know witnesses in your favor. Right to bill this matter to higher court if you lose, right to file comments, right to there's no doubt that you're guilty charge against you. Understand that by entering a guilty plea, you both those rights.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will go to the precinct investigation report and purchase. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your case. You understand that?
Yes, sir.
Okay. You step to your left, sir, hold this board.
Upon a plea of guilty to indictment number 21 CR 81 for the charge of possession of a controlled substance first degree methamphetamine, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to indictment number 23 CR 36 for the charge of possession of a controlled substance first degree methamphetamine, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to indictment number 23 CR 36 for the charge of violation of a Kentucky EPO DVO, the defendant shall serve 63 days in jail. The defendant shall receive credit for time served. The defendant shall have no contact with the victim, Stephanie Bybee. The 2.5 year sentence in indictment number 21 CR 81 and the 2.5 year sentence in indictment number 23 CR 36 shall run consecutively for a total of 5 years. He will serve 139 days in jail with the balance probated for a total of 5 years supervised. Defendant shall obtain and complete anger management counseling scheduled through probation and parole. Anger management counseling shall be set up prior to the final sentencing. Defendant shall enroll in complete substance abuse counseling scheduled through probation and parole, and this shall be set up prior to final sentencing. Defendant shall receive credit for time served and shall be released at final sentencing and after anger management and substance abuse counseling is scheduled. The defendant agrees to have any and all evidence destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency in both of the above style cases.
Is that what you agreed to?
Can I ask you a question before I say this?
You need to extra return. Okay, you understand the Commonwealth's law right now? Are you pleading guilty because you did commit the acts charged in the indictment as amended? It's been amended down, so you agree that you committed the acts in the indictment as amended?
Yes, sir.
You need to tell me.
Yes, sir.
Did you, know your constitutional rights, so explain to you, is it still your desire to give up those rights and plead guilty when I court fix your punishment as permitted?
Yes, sir.
Okay, you understand that the include guilty in future convictions or felonies will be enhanced as far as the range of penalty.
Yes, sir.
Is that your signature on the offer document there?
Yes, sir.
I'll accept the agreement or PSA. This Gordon Anderson, this was a probated sentence, is that correct? So I'll allow you to remain out until the pre-sentence investigation or still with the probation parole officer. Thank you. Okay, Jeffrey Reagan. Jeffrey Reagan. Commonwealth versus Jeffrey Reagan, 20 CR 0035. Are you Jeffrey Reagan?
Yes, sir.
Born in 1960.
Yes, sir.
Last four digits, social security number 7413.
Yes, sir.
You're on a probation revocation. You can step to the left here a little bit.
Yes, right. Mr. Reagan's got a 5-year sentence on DUI fourth, and he began having problems back in January. He had a assault fourth, which was pretrial diverted in Wayne District Court on February 20th, 2023. He's had marijuana positives May 3rd, 23, a marijuana positive from a urine sample on September the 19th, 23. And the problem probation pro's having, he's on some different medications, but he's also showing positive on medications he doesn't have prescriptions for, which is clonazepam and Xanax, along with the marijuana, according to the violation report I've got.
Judge, I'm not gonna come before you and tell you that, Mr. Reagan has a valid prescription for marijuana. But he did provide me before court a list of a host of medications, some of those being controlled substances. I will note, as evident from his arm being bandaged up, he did sustain a pretty serious injury to his left arm.
Well, I'm not a doctor. I keep looking at this stuff.
We have to have Mr. Morrow here and present testimony. Evidently, Mr. Morrow, Mr. Reagan's been good about providing prescriptions, and he's furnished those prescriptions to the lab. If the court looks at the violation report, you can see the items that the prescriptions cover and the items they don't cover. So, according to the lab person. So, that's the problem they've got.
What do you want to do?
Well, this is a case that we were directed to put before the court. You know, I don't know any treatment available that would help Mr. Reagan because he's taking all these other controlled substances. And it's either leaving on probation.
You have a driver's license, you have a driver's license there.
No, sir.
His probation parole officer. Youth.
More of the other obligations and basis.
It should be.
Well, I'm gonna put this off for I've had a probation parole officer here. Until then, I'm gonna put you on a 24-hour curfew at your house. Okay?
Okay.
Okay, you can go to church, you can go to the doctor, you know, or go with somebody, I guess, if they go to the grocery store. You usually go with somebody when they go to the grocery store, or somebody go for you.
I go usually around the first month.
Somebody takes you.
Yes.
Okay, well, you understand those new restrictions on it. Now, here's a situation, Trey. I believe that you are addicted to various drugs, whether they might be prescription drugs or other drugs, and you're self-medicated with marijuana. And you just can't be doing that with these other drugs. You take the prescription drugs, but all these other drugs, not so much. Now, I really don't want, it appears to me that you're, and I'm not criticizing you, but that you might be a little bit infirm as far as your health is concerned. I don't think you would do too well in jail.
No, sir.
But I will send you there if you don't work with us. You understand why they got their job to do too.
Yes, sir.
Okay, so keep in contact with your attorney. If you want to have a clinician take a look at him. There's not much I can do to you but send you up. So between now and you'll be back here on December 7th. We'll consider what we're going to do, okay?
Yes, Your Honor.
Kelvin Riviera. Kelvin Riviera. Carlos versus Kelvin Riviera. Are you Kelvin Riviera?
Hey, yes.
Yes. Wanted that to take it now.
Judge, he needs an interpreter, but we had a Spanish interpreter before, and it's my understanding from speaking with Mr. Rodriguez and his family that he actually speaks Puerto Rican more than his Spanish.
There's no Puerto Rican language.
They're not like these big person.
Really, dialect is still Spanish. They speak Spanish in Puerto Rico, throughout the Caribbean, a lot of South America, Mexico.
Well, Judge, we have a resolution, and Mr. Rodriguez brought a translator with him.
It isn't a translator, and I can't do it without a translator. You have to bring a translator. I know, but he'll have to have a translator so he can talk to him too. We
We've already got that. They've got the complete case.
Yeah, we're, I guess we're ready to go, but I was able to use the translator Mr. Rodriguez brought with us.
He has a translator, is she certified
No.
to be cool with it? It's a problem. If you will waive him having a translator and we'll have to have a translator from AOC.
But
I mean, I can't read down through these things and understand what he knows it unless I have a translator that's certified to be here. So does he have any problem being here on December 7th? What was the resolution of it?
It was a plea, Your Honor, of home incarceration. I understand he has a job at Tyson, been working now, he's gonna do that.
Was it pre-trial version?
Is diversion.
Okay, well, let's put him on a curfew, tell his family members on the curfew to go to work, church, or the doctor, okay?
It's not legal. Yeah, sir.
We'll get it over the next time, right?
yes, Your Honor.
Okay, thank you. Make sure we request the interpreter. Jonah Stockton. Jonah Stockton. Jonah Stockton says to submit documents.
My understanding is, I don't know if Mr.
No.
Pennington has them or not.
Do what?
The plea papers were misplaced when he entered his plea. He's in drug court, and he's currently at Crossroads Rehab in London. So if they have to be re-signed, we either have to mail them to them or whatever. We need to get it out.
It is possible that Brad Shepard has them in his file.
Yeah.
That has happened numerous times before.
Yeah, Mr. Stockton was one, he was one of my first ones. So I do not have the paperwork.
You want to call Shepard, see if he has.
I have tried. I've actually I've been to the Columbia office looking for, and they're not at that office.
So we're gonna have to
So,
go back. to-
I don't mind, I go through London on my trek, I don't mind I didn't know it was there, I don't mind to get with him there and execute the documents.
Yeah, I don't know why you go through London.
I live in Manchester.
So I'd go to Mount Vernon and come back down if I had to.
That's still London. I still.
Okay, well, we'll just schedule, put it on the docket again next month.
That'd be fine. Thank you. And can we do an order releasing the bond holder? We've had that policy at our office. He's already entered the plea.
They said they can't release the one.
I think that's probably-
I'll give a court can. The court can order the bond released. I mean, the case is concluded. It's just an administrative.
Who is it?
I don't even know.
Well,
I can't
it's
remember.
a cash bond.
I don't know if the clerk can check. I believe.
Well, let's just leave it in place. We'll take a look at it because we got to move on here. That's not for cash.
I'll just submit an order to court.
Now, there's nobody else here live, so we're going to, I guess we see, is Adair County on there? Adair County. Got a couple of Cumberland County cases. Wayne is not on yet. Russell County, you want to come, Russell County? Detention.
Yes, Your Honor, we're on here.
You have Stephen Bridgman.
We have Mr. Bridgman, and we have Mr. Phillips, and we have Mr. Kraft. Mr. Bridgman, go ahead and take your seat.
They're going back there and see what works out here now. Can we go tell them?
Jesse George is in Russell. I think Jesse Pittman, that's in Wayne, so. But he was transported. I think that's-
This is working out here now, Commonwealth versus Steve Bridgman. Is Mr. Stockton gonna do this, or who's gonna do it? It works out here now, Mr. Stockton. The technology changes all the time. It's like Turkey, we look at the new day every day. Commonwealth versus Stephen Bridgman, 23 CR 0001. Are you Stephen Bridgman? Are you Stephen Bridgman?
Yes, I am.
This is a motion for short probation, Mr. Poindexter.
Your Honor, Mr. Stockton and I have spoken. He has another case that's a possession of meth. And David Cross represents him on that, but me and Mr. Cross and Mr. Bridgman have spoken. He is going to enter a plea on another day to that other case. And on this case, Mr. Stockton is agreeing to shock him to drug court after he enters that plea.
If the court's willing, I'm willing to have him assessed, and if he qualifies, I told Mr. Poindexter, I've never agreed to shock probation on a case after I've had a jury trial, but since his wife passed away in the situation with his child, and I've known Mr. Bridgman for a long time, he used to be a productive citizen until he became, I would say, a frequent user of drugs. So if the court wants to consider that, I'll go along with it.
Well, let's hold an advance motion for short probation.
That's correct.
And then take a look at the other cases, see what the plea is, and we can roll this one over into that, we'll take a look at it.
That's what
So we have him assessed in the meantime, Your Honor?
I don't particularly want to do that until I see the other case.
Okay.
Okay.
What is the other case say?
Well, it's not been said, it's just been lingering out there, it's been on the docket. Mr. Cross had, and I had to put it on there.
Let's put it on the docket on December 7th. You want him assessed now, or how do you want him?
It doesn't matter to me, I know he's got in about 3 or 4 months, so whatever the court wants to do.
Well, we can have him assessed, it doesn't matter, we ultimately do it, we can have him assessed, see if he's qualified. And redocket his other case for December 7th, we could roll it up if that's the case. Mr.
Bridgman.
No, I was trying, I'm sorry, December 7th. Mr. Bridgman, you've got I don't have your other case now, so you've got a pending case, and what your attorneys agreed with the Commonwealth to do is schedule your other case for December 7th. Between now and then, have you assessed for drug court, and maybe roll those two things together and get you out, put you in drug court. So you expect somebody to come over and interview you, get ready for that, and not be able to roll everything up on December 7th. They'll have to vote you in drug court at the next drug court meeting, and then I'll let you out for an orientation if you decide to go. So things are looking up for you, okay? Just be ready for somebody. You understand what I've said to you?
Yes.
Okay, thank you very much.
Yeah.
22 CR 00069 is the other case that needs to be on docket. You said Cross represents you on that?
He does, and I'll ask him to stand in for me on the 7th because I'll be out of state. Yes, sir.
Commonwealth versus Donald Kraft. Are you Donald Kraft?
Yes, Your Honor.
And we're here on 22 CR 0074. Okay, y'all are keying the mic over there. 22 CR 0074. Mr. Kraft, were you born in 1972?
Correct.
Last 4 digits, social security number 3460.
Right.
Okay, what's the Commonwealth have in this case? It says probation.
We had a hearing last month, and the court had, was going to review it after he met with SSC. My understanding was he was going tomorrow or today to a long-term treatment. Is that correct? That's what Mr. Furl told me. So
What's the Commonwealth want to do?
that was fine. I was ready to revoke him last month, but if he's available, got a long-term court, that bed date and keep it and we'll use it, I'll be glad to let
I'll
them go.
hold the motion to revoke in
They've
abeyance.
already assessed me to go to rehab. They've already assessed me to go to rehab.
I understand that. I understand. They've got a bed date for you. So I'm gonna hold in abeyance a motion to revoke. You go to this rehab, where is the rehab? Where?
Well,
What's the name of it?
like this is thinking.
It's okay. If you drop out of that rehab or leave, you come directly back to the Russell County Jail. You understand what I'm saying, or you'll be absconding?
Yes, Your Honor, I understand you.
Okay, thank you very much. Russell County, you have, okay, what's his name? Jesse Phillips there?
Yes, Your Honor.
Good morning, Your Honor.
Commonwealth versus Jesse Phillips.
Your Honor, this is our shock or motion for shock probation.
Which Commonwealth versus Jesse Phillips, 23 CR 0029. Are you Jesse Phillips?
Yes, sir, I am.
Born in 1987.
Do what, sir?
In 1987.
Yes, sir.
Last four digits, social security number 8876.
Yes.
What's the Commonwealth have in this case?
Your Honor, this is, if you recall, this is the case we had 2 or 3 months ago on the docket. If you recall, this is the case we had 2 or 3 months ago on the docket, and Mr. Phillips did a naked plea in front of the court the day we had the jury come in on a possession case. 3-year sentence is what he received. So if the court does shock probate him, I think he ought at least have to pay the jury costs.
Well, how long has he been in?
He's been in about 3 months. I was asking Miss Clooney to check and see when he's parole eligible.
And Judge, in our motion, we had,
We'll go behind the microphone.
yes, Your Honor, in our motion, we had noted that Mr. Phillips has agreed, is willing and wanting to actually seek long-term rehabilitation.
When's he gonna be paroled?
In January. So I would suggest if he doesn't make parole, redo the motion for rehab.
Judge, Mr. Phillips tells me he wants to go to rehab, and Judge, I do understand logistically parole may be in Mr. Phillips' better interest. But if the court will recall, Mr. Phillips tried to enter a motion to enter guilty plea with probation. Didn't act as he should have, and acknowledges that. And Judge, in his 3 months there, I will give him some credit aside from the beer. This is the best shape he's been in the time that I've known him.
Well, you know, I don't think it's his best interest not to go to parole, but Mr. Stockton, if he insists he wants to try a rehab, realizing that if he busts out of rehab, if I revoke his probation.
Absolutely.
It'll do damage to him on the parole board next look at it. You agree with that, Mr. Stockton?
He will. But if he goes and completes it, the ball will be in his court.
Yeah, well, go ahead, I'll hold an abeyance motion for shock probation, and you get a rehab that's acceptable to the Commonwealth, and y'all submit me an agreed order, and we'll get Mr. Jesse Phillips an opportunity to go to rehab and continue to make progress, okay?
Thank you, Judge. Jesse, I'll be able to talk to you.
Thank you, Judge. I appreciate you, Your Honor.
Okay, good luck to you. Do we have anybody else in Russell County? If not, thank you for cooperation.
That's it.
Thank you all very much. Okay, we have an Adair County, it doesn't appear to be on there. This juncture, so let's go to Clinton County. Clinton County. It says. Clinton County, Edwin Daly. Commonwealth versus Edward Daly. Are you Edward Daly?
Yes, sir, I am.
We're here today for the purpose of sentencing. Have you read the pre-sentence investigation report that been done by probation and parole? Have you seen that?
Yeah, uh-huh.
Is it substantially correct? Is it correct? The things that in the report are correct?
It's incorrect.
Yes. Yes, sir.
Mr. Cross, is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On a plea of wanton endangerment first degree, the defendant shall receive a sentence of 5 years on each count to run concurrently for 5 years. On plea of guilty criminal mischief, he shall receive a sentence of 3 years. The 2 years are to run consecutively for 8 years, probated for 5 years, probation to be supervised. Defendant shall receive credit for time served and shall pay restitution to Jonathan Cravens in the amount of $600 to be paid $50 per month beginning 30 days after he is released. That's what I'm going to do. The first of this kind of month. So which will be December 1st.
Be better, yes.
The defendant shall not have any firearm on his person, residence, or vehicle. What are the court costs?
$155.
Court costs are $155. In addition to the $50 a month restitution, you'll pay $30 of the court costs starting 30 days from today. Okay.
Eugene, you'll get out today.
And you need to go to the probation and parole office today.
That'll be tough, I'd say.
What time? Could you? 9 o'clock Central Time in, go to Monticello. Go to the, you know where the probation and parole officer is, sir, in Monticello?
Eugene, as soon as you get out, come by my office, okay?
Okay. Okay.
Jeremy Kemp. Thank you, Mr. Davis. Now we do Jeremy Kemp. Are you Jeremy Kempton?
Yes, sir.
This is 23 CR 0030. Mr. Kempton, what is your year of birth?
81,
Last 4 digits of your social security number.
2874.
You're for sentencing today. If you had an opportunity to look at this investigation report done by probation parole.
I looked at this morning.
Have you gone over the pre-sentence investigation report done by probation and parole with your lawyer? Have you gone over it?
Yes,
Okay, does everything in there appear to be substantially correct?
yes.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty of assault, 2 counts, he shall receive a sentence of 5 years on each count to run concurrently, total 5 years. Serve 151 days in jail with a balance probated for 5 years supervised. The defendant shall be administered his medication for substance use and mental illness by inoculation. Proof should be submitted to probation and parole each month. He shall receive credit for time served. He shall obtain gainful employment and do 30 hours per week public service. And any evidence will be destroyed in a manner consistent with the rules of Commonwealth protecting laws. What is the court cost? $155. You need some time to pay the court cost on this.
Yes.
Well, I'll let you pay the first payment, $30 a month, starting 30 days from today. That'll give you some time. Okay, thank you very much. Ricky Wright. Commonwealth of Kentucky versus Ricky Wright, 21 CR 0015. Are you Ricky Wright?
Yes,
What year were you born, Mr. Wright?
1963,
Last four digits of your social security number or what?
6439.
We were here at 21 CR 0015, which is a probation revocation case. What does the Commonwealth have to say in this case?
Your Honor, Mr. Wright has a 7-year sentence on trafficking.
Wait,
Mr. Wright has a 7-year sentence on trafficking. Kind of odd, he was assessed, and in lieu of revocation, he was sent to the healing place in Campbellsville in July of 22. They discharged him after he had 2 positive tests for marijuana. Then he reported to Officer Clooney, and he tested negative for all panels. That was July 25th of 22. And he was supposed to come back August the 19th of 22, and he absconded. We hadn't seen him since. So it's been a little over a year.
Counsel. Stipulate.
Judge, I've not had a chance to speak with Mr. Wright, but
Okay, well, we can put it off.
I
Mr.
would,
Wright, your attorney's gonna come up and speak to you. I don't think it's fair to you or you to do anything until you talk to him. So I'm gonna schedule your case on December the 7th.
thank you, Your Honor.
Maybe you can explain this to me.
I'll be able to speak to you, sir.
Okay.
Is anybody else at jail at Clinton County that's on the docket? Got an add-on,
He's in there.
Mr. Robert Warren Scott Harris, is that what it is?
Oh, I told the victim that she could leave because I didn't think he got aid out.
Well,
How everybody communicated last night, I'm sorry,
You may have, you probably seen it, but I just didn't see it.
No, I got an email saying that the PSI was done,
Oh,
and
okay.
the jail emailed me, which now we can go for these.
Yeah, if you can pass a few minutes, we'll try to call her. If not, we'll go forward.
where is she?
She was waiting in court, and I just was trying to be nice and tell her that it wasn't on the docket because it
No
wasn't on the
good
docket.
deed goes unpunished.
That's correct. So I told her to leave, and I didn't know it was on.
So that complete, but except for him, is that complete criminal docket, except for telling him Dare County Jail? Did someone call it a Dare County Jail?
It's just since.
We're finished.
Yeah. Well, he's got a case in terms of Canada. Got out of here. Robert Knight.
Where are we going here?
Scott Harris.
Okay, Commonwealth of Kentucky versus Robert Warren. Scott Harris. Are you Scott Harris?
Yes, sir.
What's your full name?
Robert Warren Scott Harris.
You're here to be sentenced today.
Yes, sir.
You had an opportunity to look at the pre-sentence investigation.
Yes, sir.
This is 23 CR 0031. Counselor, you and the client found everything substantially correct.
Yes, Your Honor.
Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
The Commonwealth recommended a sentence of 5 years, probated 5 years, under the supervision of probation and parole. The defendant is to enroll in complete anger management and have no contact with the victim. Now, Mr. Stockton, the victim is present here in court today.
She is.
Is this acceptable to you, ma'am? Also on assault, 4th degree, well, months, and I guess that will run probated with the felony, is that correct?
That's correct.
What are the court costs involved? $155. Mr. Harris, I know you've been incarcerated for a while. The court costs are $155, so I'll let you have 30 days before you have to pay. You pay $30 a month. Start 30 days from today. You think you can do that?
I can do that, sir.
Now, I want you to take this anger management thing very seriously.
No problem, sir. I'll do everything they ask me.
You get out today and you go to probation and parole office at 9 a.m. Central Time in Monticello tomorrow.
Okay.
Okay, thank you very much.
What day is that, sir? Tomorrow?
Tomorrow is sunrise tomorrow.
Okay, 9 a.m. tomorrow, Friday morning.
That's right.
Okay.
Monticello time. Thank you.
Okay, thank you, sir.
And we haven't gotten to Dare County on it yet. Okay, let's go off the record till we get there. Oh, there's Dare County, there's Dare County. Thank you very much. Adair County. We have a Cumberland County case there, Lance Humphrey. You have Lance Humphrey.
Yeah, it's on.
Are you Lance Humphrey?
Yes, sir.
1996.
Hey, excuse me?
You born in 1996?
Yes, sir.
Last 4 digits of your social security number 5319.
Yes, sir.
You're on 21 CR 0018 for probation revocation and 22 CR 0057 for a pretrial conference. What is a conference say?
We have a felony plea, Your Honor.
Okay, a motion has been, Lance, a motion has been filed that says you wish to enter a plea today. Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol.
No, sir.
Is this plea freely and voluntarily given? You're doing this of your own free will, is that correct?
Yes, sir.
Are you the same person indicted in case number 22 CR 0057?
Yes, Your Honor.
Yeah. Are you impaired in any way today? You know what's going on here?
Yes, sir.
Have you had plenty of time to talk about this matter to your attorney, and are you satisfied with his advice?
Yes, sir.
You view the evidence the Commonwealth has against you, and you believe you're fully informed about your case.
Yes, sir.
You have certain rights under the Kentucky United States Constitution. Before I can take a plea, I'm going to go over these rights. At the end of them, I'll ask you if you understand them, okay? You have the right not to testify against yourself. No one can make the same thing. Right to speed trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. Right to call witnesses in your favor. Right to bill this matter to higher court. If you lose, the right to require the Commonwealth to prove without a reasonable doubt that you are guilty of charges against you. You understand that by entering guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply the range of sentence provided law. I don't have to accept it. Prior to accepting the recommendation, I will wait the pre-sentence investigation for it to be done on probation and parole. In the event that I do not accept the recommendation, the Commonwealth imposes partial sentence, you have a right to withdraw your plea to proceed to trial. Mr. Stockton, you want to come forward and listen very carefully to see if this is what you do.
Your Honor, in case number 22 CR 57, he will plead guilty to tampering with a prisoner monitored device and second degree, receive a sentence of 5 years on each to run consecutively for a total of 10 years, probated for 5 years. Sentences to run concurrently with Cumberland Circuit Court case 21 CR 18, where he will receive credit for 185 days as a sanction on a motion to revoke. He shall be remain incarcerated and be released to a dual diagnosis rehabilitation for mental health and substance abuse treatment. If he leaves the facility or is not without proper discharge, he will report to probation and parole immediately. The probation is to be supervised for 5 years.
Is that what you agreed to, Lance?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts and the indictment as amended?
Yes, sir.
All your constitutional rights to still your desire to waive those rights, enter guilty plea and allow the court to fix your punishment. Is that correct?
I'm sorry, one more time.
Knowing your constitutional rights and still your desire to proceed and allow the court to fix your punishment. Is that correct?
Yes, sir.
You understand that after any guilty plea to these, that if you have felonies in the future, you can get enhanced sentence because of that, because of these pleas. You understand that?
Yes.
This is your signature on the document that I have here. Let me hold it up there and let you see it.
Yes, sir. In blue ink.
Yeah. Okay, well, I'll accept the plea and order. Is there a need for a PSI in this case, I guess? PSI.
Probation and parole came yesterday and asked me what had changed on my PSI, and I told them.
Has he been a state prisoner?
No, Your Honor.
Yeah, so what, they'll fill that PSI and we'll send it you on, November 16th. And will the probation start there or you go to the institution?
Yeah, I guess probation and parole needs to assist him maybe about getting the plate. Are you doing that?
Alright.
Okay.
Where are you talking about?
Judge, all of ARC's centers are dual diagnosis, so that's where we're kind of looking right now. But I'm also working with our social worker in our Glasgow office to see if there's something better for Lance.
November 16th, and maybe you give him a bed date shortly thereafter.
Absolutely.
Gonna come to Burnsville on November 16th, Lance, and they'll try to find you a placement, okay?
Will I have a bed open by November?
Well, that's what they're working on. They're gonna try to get you as soon after November 16th. They think that they need to put you in a dual diagnosis, so they'll be working on it, and they'll tell you something on that November date, 16th, okay? Thank you very much.
All right.
Yeah.
Thank you.
Jameson Mallon. Commonwealth versus Jameson Mallon. For sentencing in 23 CR 0008. Are you Jameson Mallon?
Yes, Your Honor.
Born in 2003.
Yes, sir.
Leads to social security number 6011.
Yes, Your Honor.
We had an opportunity to look through the pre-sentence investigation report done by probation parole.
Yes, sir.
It's substantially correct.
Yes, sir.
Counselor, is there any reason not to sentence this gentleman?
Judge, there is. I have not had a chance to go over the PSI with Mr. Malm. I guess he's saying he reviewed it. I don't know how, but he also has a case in Cumberland County. Mr. Stockton and I are going to try to.
This is a county.
See, he got
from the time of the plea until this sentence, and he got picked up on new felony charges in Cumberland County. He got indicted. And I when I asked the court to delay sentencing, and see if we could wrap both cases up at once.
You know, I need to correct what I said. This is Clinton Circuit Court.
Yes.
23 CR 0008 for sentencing. What's the number on the county?
So we bring in
23 CR 92.
Well, and that's pending case.
that's pending
Well,
case.
for the purpose of judicial economy, would y'all have any objections to transfer in this case to Cumberland County?
That's fine.
No, Your Honor.
Let's transfer to Cumberland County. We can handle that case over there in this one. That won't bother you, but. Okay, when's the case scheduled for over there?
Negotiation day, November 8th, next date, November 16th.
November 16th in Cumberland County. I'll try to wrap these two cases up together for you, sir. Okay, the Clinton and Cumberland case. All right?
Thank you, Your Honor.
Thank you. Cumberland County case, Quayshawn Thomas for sentencing. Cumberland versus Quayshawn Thomas, 23 CR 0042. Are you Quayshawn Thomas?
Yes, sir.
Born in 1997.
Yes, sir.
4 years of social security under 3952. Is that correct?
Yes, sir.
Your day for sentencing, if you had the opportunity to look at the pre-sentence investigation report done by probation and parole. Is your lawyer going over this probation and parole?
Yes, sir.
Is it substantially correct, Councilman?
Yes, sir.
Is there any reason this gentleman should not be sentenced?
No, Judge.
On plea of guilty possession of a firearm by a convicted felon, receive a sentence of 4 years to serve. And shall forfeit any interest in the handgun. What are the court costs? Well, I'll give you, start paying $30 a month, 30 days after it gets out, okay? Thank you very much, sir. Okay, Adair County, do you have anything else for us? Not, we'll recess until what, 1 o'clock. Thank you.
Mr. Williams,
Oh, I'm sorry, right here, we got 4 hours.
Mr. Williams, Mr. Williams, am I good?
Good, okay, thank you very much.
So what, am I waiting to, go down now, like to get shipped?
They'll be transported soon, they ought to get you out of there, so it's your large facility.
Okay, thank you.
Very much.
I screened recording.
Sloan versus Sloan.
Read order, Judge.
Garrett versus Goodman.
Judge, that, will be renoticed, that's being passed.
Cabinet versus Mark
Read order, Judge.
Cabinet versus Hutcherson.
Judge will renotice that.
Porter versus Arnold.
Have an agreed order, Judge.
Ketchum versus Anderson.
That one's not a child support case, Judge.
Motion to modify is what it says, so I think
Oh, I don't think it's the child, I don't think it's our motion, I think it's other parties involved.
yeah, I'll call it Cabinet versus Ferguson.
Agreed order, Judge.
Mason versus Mason.
Agreed order, Judge.
Okay, now, if y'all got the situation, let me call this other case, and I'll talk to you off the record. I'll stay around with the earshot on this one here. I guess we have Catherine versus Anderson.
This was, I think, incorrectly docketed time-wise, Your Honor. It's a motion to modify visitation for the civil motion hour. I'm representing Ms. Anderson in that.
Do you have a lawyer?
Yes, Mr. Cross. Sort of an ongoing thing.
Well, just a second. Give it a turn. Okay, Catherine versus Anderson. Go ahead.
This is just a motion to modify
Tell
the
me what you want to do, what you want.
once-a-week supervised visitation for my client with the child. She has evidence of sobriety and stable employment now. She just wants to have resumed contact with the child.
Your Honor,
If y'all move over this way, that's
we haven't had any contact with Miss Anderson in about 2 years. About 2 years. She's not had any contact with the child. Whereabouts unknown, as they say. Couldn't ascertain where she was to get to know if we could file a termination case on her and how to get her served. It doesn't do any good to file one if you don't know where somebody is. So when we got the motion, I'm happy that Ms. Anderson is apparently doing better. And I realize if someone wants only one supervised visit per week, that's about as slow a start as you can make, and that's the way it ought to be. But I do think she ought to be subject to a hair follicle test. And
We have no objections to that, Your Honor. We're actually prepared to provide drug screening that was taken as recently as 2 weeks ago already.
We have a supervised visitation area here now, the cabinet living or anything like that.
Not really.
We do have a proposed supervisor.
Who is?
Either her mother is willing to supervise, she's a CPS worker out in Indiana, and she's willing to travel to here to supervise the visits, or Miss Anderson's caseworker, she is in a long-term program to.
Who is the caseworker?
What's her? Brooke Sutherland.
Where's she located?
Lexington, where my client is located, but they're willing to
We're gonna
travel.
have somebody here.
Okay.
We're not, how many children, 1, 2? How,
2.5, 3.
2.5, she'll be 3 in January.
3 and little girl? Little girl.
They are willing to meet here and have the visitation here in whichever area they deem appropriate.
You would suggest that it would be amenable to having.
Not really, I would have to look into it.
Have to ponder on that. We might come up with somebody, give us a little
I
time.
might come up with someone, but.
All right, yeah. Have you ever lived here?
Yes, sir.
Are you from here?
I've pretty much lived here since I graduated,
Well, the reason I graduated high school or what?
graduated high school.
Well,
I've
did
been
you
here
go,
pretty
did you
much
go to
all-
high school here?
Yes, sir. I went to middle school all throughout.
Okay, well, the reason I'm asking is that there might be somebody you can think of that is a, relative. Well, a lot of people don't want to get pulled into these things, that want to be there for the supervised visitation. So I will, let it have an hour or 2 weeks, did you say, or an hour?
An hour a week is what we were requesting.
If you can reach to someone that's agreeable, I will have a hearing on somebody that's acceptable. Obviously, you would want someone, since she's been gone, to secure the fact that nobody leaves with a child or anything like that. Those parts unknown. Okay, so I'll sign something, y'all can reach somebody.
Well, let's get in touch next week. You may get a name, we may come up with a name.
Could we propose potentially a video call in the meantime so she can have some contact with the child?
Looks like,
Just before we can organize a supervisor, so she can have a phone call or a video call
well,
with the child?
here's the thing about it. This child is too young. Just get a phone call out of somewhere, somebody should talk to. Let's ease into the thing, and then, we have to have someone that, it would be better if you had someone with some background with having children, a social worker, somebody there, so you're in a transition. Just see how the child's gonna react. Traumatize the child. You just talk to her.
She has not.
But I don't want this to go on, okay? So y'all just go ahead and try to work something out, but I'm not gonna have anything.
I do not. I don't believe so.
Okay, thank y'all very much.
Thank you, John.
What do we have set up for that?
Yeah, we have a civil docket that starts at 1:30. There's anyone, both parties are present.
Your Honor, I represent Wade Weston, and I think the attorney on the other side, over an annuity was Tommy Zale. He advised me that he was gonna call your office and ask just to pass it. I don't know if he did or not. One other case I have, Your Honor.
You represent the individual that's trying to sell the annuity?
Yes, and he is present. Wade Weston, I do. He is not going to. We also have a divorce on the docket. And it's on the docket today, Your Honor, and we have an agreement worked out. His,
Well, we haven't had a call that, so the other side is, of course, the other side.
it's, the associate of Mr. Cross, Ms. Fields, but she, is going to get
I
her
don't see it
client.
on the docket.
The annuity one's not on the docket. He must have called it first.
Yes, okay. The divorce action, though, we have an agreement we're gonna have signed by tomorrow and submit it for a decree.
Okay,
And it
well,
should-
pass over that.
It should resolve.
Let's go off here. We'll wait till time comes for the rest of it. Thank you.
Your Honor, I'm also here on Mr. Orton.
versus Clark. Mitchell versus Mitchell. Which case will this be described? Mitchell versus Mitchell. We're still like 5 minutes early, so it's okay. This is Mitchell versus Mitchell, is that right?
Yes.
What do we have?
Our motion for temporary visitation and for a final hearing, and it's done basically out of frustration with the perpetual delaying tactics on the part of Ms. Mitchell.
Give me some factual situations.
I'll do so, Your Honor.
Were y'all married to each other?
They were married in Tennessee. It was a tumultuous relationship. They were divorced, I believe, in 2018 or 19. At that point in time.
One child?
Yes. Sorry. At that point in time, no contact order. Mr. Mitchell had. Mr. Mitchell had. Where's your attorney?
I'm not sure yet.
We better wait on Ms. Huntley.
You represent that attorney?
I am, yes.
Who is your attorney?
Allison Huntley.
Sweet.
Yeah.
That'd be great.
That's okay. Brewington versus Brewington. Brewington versus Brewington.
Yes, Your Honor. Your Honor, we have filed a divorce. Well, the respondent is represented by counsel, and they've got a motion in the record. Larry Conley from Corbin.
We'll just wait.
Yes.
Minutes early. Early call. Let's go off of it.
testimony in the case, Judge, and kind of outlined the basis for the motion. I apologize. I filed it back in the spring. We just renoticed it. So,
So, what do you have to say about it? It's obviously one word motion.
Your Honor, the evidence in this case is conflicting. But Dr. Seligson, who is a surgeon at the University of Louisville, performed 2 repairs on, we had a broken humerus. And Dr. Reddy in Glasgow did a repair, it failed. Dr. Seligson in Louisville did 2 repairs. The final repair is essentially successful, but he testified, he was asked, is this in fact a permanent condition? And he answered yes. If you have a permanent injury, you're entitled to instruction on permanent repair. Law's clear on that. And
Was he asked about the impairment?
not a rating, just that he had a permanent impairment, permanent condition. And if you have a permanent condition, the law in Kentucky is that you're entitled to instruction on permanent impairment.
as I understood his testimony, the permanent condition was he has a rod in his arm, but he also testified that when he was discharged, he had full use of his arm, no restrictions, and was doing well.
Well, everybody would want one. You know,
He went on to testify this healing process takes 10 to 15 years before it's fully healed.
but I think I'm gonna partial suffrage. That's one of the seriousness of the injury. Now, how many days, is everything ready to go in this case?
I think so, Judge.
Give me a thumbnail sketch about how it's happened and who's left.
There's only
We
one.
got all the people that let borrow the cars and the people that slap on signs on the side.
The driver of the car is the only remaining defendant, Mr. Larkin. The accident happened out here at the junction. He ran a stop sign. Not meaning to speak for him, but his defense was the brakes failed.
On the bar vehicle.
Or vehicle.
Mr.
Well,
Mr. Orton is still in the case.
Yeah,
too.
Mr. Orton is the
Owner of the vehicle.
owner of the vehicle still in the case. And
Judge, I think we're pretty much ready. Tom and
How
I.
many days to take to try this case? 2.
I think 2 days we do it.
2. You get, how long we got each 2?
They're
I
all-
think Tom had asked for a free trial date. I agree. We'll probably need a free trial to address motions and limiting.
Well, let's do that next month. We'll be here on December 7th, motion and limits for the next month. And then, let's,
I thought somebody jumped in on Zoom with Mr. Warren.
I don't think so.
No, Morgan in this case. They grab about every other case, Judge, but they didn't get this one.
Better hold on there. think you want February, is that?
That would work for us, Judge.
Judge, I'm clear the week of.
Well, the 19th and 20th would be good for us because it's prosecutor's
I'm a prosecutor, but I can skip the conference.
We've got trials set for the 19th and 20th. Other than that, February is fairly open, but unfortunately, another judge may have had the same wise thought that we had prosecutors.
So the 29th and 30th of January.
That would not work for me, Judge.
Fifth and sixth of February.
I could make that work, Judge.
Yes, that works, Your Honor.
We have the instructions in from you guys yet, the essential instructions. So I guess if there were any changes in the proposed instructions, after our motion. Our attention.
Judge, we were talking about stipulating to the admissibility of all the medical records in this case, except for any arguments based on relevance. Is that fair, Tom?
As to the authenticity of any of the medical records, stipulate.
Would you want us to file a stipulation on that?
Your Honor, one other, I don't think it will be an issue. My firm is technically a record still for both defendants before Mr. Paul's joined her. I do think there may be a conflict there between Mr. Larkin and Mr. Horton. Mr. Larkin has retained private counsel that is going to agree to a conflict waiver. We will stay in as to Horton. Mr. Paul will represent Mr. Larkin. So a motion to withdraw as it relates to Mr. Larkin will be coming before the court, but I don't think that will delay a trial.
I'll take that order.
If you have any objection to that, Mr. Carroll?
No.
I didn't think so. I just wanted to make sure the court was aware that that wasn't something that would delay trial. So we'll tender, once we have a signed conflict waiver from Mr. Larkin, we will circulate the tender.
I'll see you on the 7th, pre-trial motions. We don't like to hold this thing. So then with any other pre-trial motions. So, we'll try
Thank you, Judge.
Thanks, Your Honor.
Mitchell versus Mitchell.
A nice trip down. It's not the first time somebody didn't make the right turn.
I do apologize. The GPS was not working in the vehicle. and
I'm a little dragging today. I watched Cousin Vinny last night about 29 times. See me using their eyes there. Okay, what do we have?
Your Honor, this case goes back to a tumultuous marriage. Mr. Mitchell was having major issues. There was domestic violence in 2018, I believe.
Visitation now.
I'm gonna leave.
Well, I don't wanna, what do you want?
Well, Your Honor, I want a temporary visitation order, and when we were in court on this on June 23rd, you basically told counsel, Mr. Garman at the time, that you were going to order visitation, but the parties ought to mediate. But then they dismissed Mr. Garman as attorney. They've now got the very capable hands of Ms. Hunley. We set mediation, and then lo and behold, about a week before that, it was canceled because the respondent had had a baby. And I'm sure it was a full-term thing there. I mean, I guess my frustration is, Your Honor, and I'm very frustrated, but I'm not near as frustrated as Mr. Mitchell.
Okay, well, let's get at the solution. What is your client willing to do?
Well, here's the issue. There's currently a no contact order, she said, that protects both her and the children. There are some things she would like him to do.
Where is it, in this court or this court?
It was in Pickett County, Tennessee. And I've attached at least a temporary order. She says that they went back to court and that was extended. You know, here were our initial thoughts. If we went to mediation, we were going to offer him to do some things: domestic violence assessment, batteries intervention, anger management, just some things to make sure that he had dealt with the issues. I mean, there was some significant domestic violence, and in fact, I don't think it wasn't that they let Mr. Garman go. It was the fact, I think she wasn't aware of this motion and just different things, I think, that happened. In no way, I mean, we're happy to mediate this to try to make a resolution. And there are just some things that need to be done, some safeguards. This is not just your typical case where someone's just not getting visits. There's just been some, and the kids have not seen him in several times. I mean, even if he had done all these things, we're in a perfect place, we would still want there to be therapeutic visits or something to kind of get things going. It's just not your typical case.
Well, I suggest mediation.
Your Honor, that's what we did.
They didn't do the mediation.
They canceled.
I understand. I'm gonna order some immediate mediation. I'm not saying something a month from now, 2 months from now. I'm talking about to schedule within the next 10 days with some mediation to get the thing going again. And, you know, changing lawyers and having babies happen, but I want to tell everybody here, we're on a fast track to resolve something. We'll go to mediation, both of you will know where you are after that. You know, we might have just one child and two children. So, and they're how old now?
9 and 7, I believe.
Well, there could very well be some separation issues here that they might not want to see their dad. I don't know. Yes.
Your Honor, there are separation issues, and those have to be recognized. But those have occurred as a result of the endless delays. I'm reminded of the two.
We're here where we are now. I'm
I
not
know,
blaming
but
your
we've been
client.
trying to get this done for 3 years.
That's the reason we're gonna go to mediation to find out what sort of services that need to be done. I wanna get through some visitation, and even if it's just heavily supervised visitation first, at least that's visitation. So I don't have to be convinced of that. I also can feel the tension there. Probably the mother wishes that he would just go away. So I understand that too, but that's not gonna happen. But also, I'm not gonna hurt the children. There's a possibility of bad things happen. Everybody just needs to enter into this mediation with the thought that you need to do the most lenient things each way that you can, or I'll decide. You don't want me to decide and then you get left out. So I'm not gonna put up with a lot. I want everybody to enter in good faith, understanding at some juncture it will be important that these children understand that every parent is imperfect, but that parents haven't deserted them and don't want to see them in that way. That'll be a problem at some juncture too. So who is the mediator be acceptable to both of you? Probably.
Your Honor, we agreed on somebody in Somerset just to try to get it expedited.
Who was that?
There are two, I can't recall those two, Penny Hines, Heidi Pelley, and Linda Dalton. I know those three do in Somerset. Trying to think, I think off the top of my head, I may have time next Wednesday that's open up, or I mean, we can.
Your Honor, my question to the court is, this is where we were in June. We set the mediation. It took months to do that, and they canceled it.
Well,
we're operating on good faith, but nothing ever happened.
Well, it's gonna happen this time, okay?
And did we
Nobody,
cancel or was it?
let me tell you what, Mr. Cross, did you ever bring it to my attention that it never happened, that the mediation never happened? I didn't know the mediation never happened. The other lawyer didn't bring it. I mean, my predecessor, Judge Lovelace, knew what was happening in every file, in every case. I don't do that, but he wouldn't even know that the mediation hadn't happened, nothing had been filed. So, I mean, I have sympathy for work that it didn't happen. And it will not happen again. There will be no delay in that. So if there are, there will be repercussions and sanctions if there are anything. So everybody understands where I'm coming from now. We're gonna go in there. Let's see if we can pick a mediator in time right now, so we don't have a disagreement.
Let me get my calendar. I think I have Wednesday. Do you know what your calendar is?
Next week is a busy week, but either Ms. Fields or I will make ourselves available anytime.
Okay.
Won't we, Ms. Fields? One of us will. We'd love to get something.
Who is the mediator? Do you know these mediators that they're proposing?
Your mother would know the name. I can't think of it right off the bat.
I can't remember. We always use either Penny Heidi or Melinda.
Who you saying?
Penny Hines, Melinda Dalton, or
Okay,
Heidi.
let's go one at who's Penny Hines, a lawyer or is she?
They're all lawyers.
Yes, they're three family court lawyers.
There's no former family court judges up there that do mediation.
No, I know.
Don't get Debbie Lambert.
Judge George, well.
She's a little busy.
I don't have the name of who we had. All I know is it blew up at the last minute and we filed a motion.
And I could also do the 14th that afternoon. I could do next Wednesday
Let's do
afternoon.
next Wednesday.
Okay.
See if we can- Y'all can go back here in the back room here and call some of these people. See if they can do that.
Yeah, that's.
Erica, let's go back. We're going to come each for record.
Is there any other case on the docket?
Ms. Brewer didn't agree with you, Your Honor. Be right back out.
You wish to wish you were.
Let's go off of that. and work this process there, but that's-
Approved.
Let's go back on the record. First,
Your Honor, this one's a little confusing and the problem starts with my office. Mr. Conley represents the respondent. The respondent now lives in Winchester, Kentucky.
This is Burlington versus Burlington 23 CI 0012. It's originally referred down to the Domestic Relations Commissioner. Now, but since one party's not here, procedurally, I'd like to catch up on this.
Okay. Well, this is a brand new case. We filed the divorce. One child, how old? 1's 8 and 1's 4. Two. Triple. Okay. Now, we served her with a copy of the petition for dissolution and the motion. Now, that motion, we called over and set it for today, and that motion left our office, and unfortunately, it said November blank on the copy that was served upon the defendant. Now, for the respondent. Mr. Conley, Larry Conley of Corbin, filed a motion yesterday to strike this from the docket because there was no notice. Well, by the motion itself, they were sufficiently aware of this proceeding. I called Mr. Conley yesterday afternoon, told him I understood his motion. I said, would you like to attempt to come to a temporary agreement? He says, I don't know if I can get anything done by tomorrow or not. I just tried to call Mr. Conley about 10 minutes ago, and I got no answer at his office. Yes, they are. She left and went to Winchester. James hadn't seen him in 6 weeks. So.
Okay, well, I want you to give the notice where we at next first.
Can we do the 16th in Burks or not?
Let's sit in Burks.
Okay, 16th.
Sit in Burks.
Okay.
And,
at 1 o'clock, maybe?
you can't.
1:15. Okay.
So then.
No confusion, that's fine.
It'll be over there. So we'll try to get the commission.
That'll go out today. Thank you.
Yeah, we'll try to get the commissioner to be there too, in case you need to go downstairs.
Thank you.
All right, thank you very much.
You can't what? No, but that's 2 weeks. Right. I'll explain to you what's happened. Thank you, Your Honor. That's all we had.
Well, for American Legacy, another one next.
If you've got a trial scheduled for the 14th, we're not gonna be here. We've got, in-service, summer session. Richardson. I'm gonna go side by side. Roper side by side. Boyd's in Fort Knox, we didn't want to get him, bring him back, so.
What month is it?
November.
It wouldn't bother me to continue that case. It wouldn't bother me to continue because you get Kansas.
That's true. That's true.
The reason why we did that. That's of course the guy was moved to go into
Oh, yeah.
basic training.
Yeah,
He's got,
December the 16th, I believe is his.
that's his last day, so he's through this program exam, so he'll be gone, probably. And I talked to Penny today, and Penny said they'd make agreement on it. Jesse told me no, so.
Really know what.
Please. Penny told me he's probably plead it out. Still in the hold for him. The witness, we got the one they caught before.
Yeah, I want you to go ahead and cover all that stuff.
Scout, Jesse.
Week 13, 14, 15.
What's the sort of percent?
Election.
It's election. I look. Should take off. I think that security level. That's a big problem. Where everybody statewide gonna be in service there.
We're scheduled for it. We do a week every year.